we were discussing about the different types of evidences and the witnesses as well. See, I told you that we have oral evidence, we also have documentary evidence. And see, normally what happens when any expert or any witness is issuing a certificate, the person will be called to the court of law to give evidence, to depose. Deposition is giving evidence in the court of law. But certain situations, there are few exceptions. There are few exceptions for oral evidences wherein the person does not have to come to the court of law. Number one, the first important one is dying declaration. Dying declaration. If the declaration is given by a person, right, related to the particular unlawful act and the person is dead, right, that declaration is admitted as an evidence in the court of law. Is admitted as an evidence in the court of law if the victim is dead, right? That is important. If the victim is alive, definitely the person has to come to the court of law, right? Fine. So the second important exception is, right, any expert opinion mentioned in a treatise, or you can say any books or textbooks, right? If any opinion is given by the author in a textbook, you cannot call the author, you don't have to call the author for the court of law for deposing on that particular opinion, right? So any expert opinion mentioned in the textbooks or any printed book, right? The third important exception is medical witness, right? If the medical witness, a doctor, has given evidence in the lower court, and that deposition was given in front of the magistrate, cross-examination is also done, that evidence will be considered in the higher court as well if the accused is going for an appeal. If the accused is going for an appeal to higher court, in that case, the medical witness opinion that was mentioned in the lower court, that will be taken as such. There is no need to call the medical witness again to the higher court. Okay, again to the higher court. But in all these situations, if the judge feels, the presiding officer of the court feels that the person has to come to the court of law for giving any clarification or explanation, definitely the witness can be called. Okay, we call it as recall of the witness. Fine. In general, the medical witness evidence which is given in the lower court in front of the magistrate and cross-examination is also done, normally it is taken as an evidence in the higher court as well. Right? Do remember, that is one important point. Then we have records. What kind of records is taken as an evidence just like that, right? Even without oral evidence. Number one, any public health record. For example, when you have birth certificate, death certificate, you need not ask the official to come to the court of law for deposing on it. Any public health record. Not only that, any hospital record. For example, suppose if you have HIO chart, input-output chart, you have pulse rate, BP, whatever that is, all numerical data that is mentioned in this hospital record, that will also be taken as an evidence even without oral evidence. Fine. So in all these situations, there are exceptions to oral evidence. And certain government offices, for example, the chemical examiner, right? The chemical examiner, the director of the fingerprint bureau, any mint officer, right? All these people will not be called to the court of law. They are exempted from giving oral evidence. They are whatever certificate that they are issuing related to the case, right? There are exceptions for oral evidence. They don't have to come to the court. In general, the point is any witness who's dead, or any witness who has become incapable of giving evidence, or it's not possible to bring the witness to the court of law without unreasonable delay or expense to the court of law, that is an exemption for the oral evidence, right? All these things will be decided by the presiding officer of the court, right? So these are all the general guidelines, but again, it is decided by the presiding officer of the court, case to case basis. Fine. So do remember, these are all the oral exemptions for oral evidence. Fine. There is one more important discussion that we need to have, that is again very important for your examination purpose as well, that is called dying declaration. What is basically dying declaration? Do remember, the name itself tells you what it is. Dying, at the time of dying, the person declares, the person is giving a declaration, the person is giving a statement, right? So let us look at the definition of this dying declaration, right? So let's look at the perfect definition of it. It is a document The declaration that we are talking about, it's basically a document, just like summon I told you, that's a legal document. Likewise here, the dying declaration is basically a document made on the statement given by a dying person. The dying person has given a statement and we are making a document on it, right? And the dying person is giving a statement related to what? He is giving a statement related to the unlawful act. Right? Suppose if it is about a murder, suppose the person who is a victim in a murder case, and at the time of dying he is talking about the circumstances of his criminal case, circumstances of the unlawful act, then that will be called as dying declaration. Right? Do remember, it's a document made on the statement. Statement is given by dying person and we are making a document on it. Right? So that is called dying declaration. So this is basically a kind of hearsay evidence. Right? And it can also be called as documentary evidence. Fine. You are making a document. See, you are making a document on the statement told by the victim. You are hearing. Right? So you are a hearsay evidence and you are making a document on it. That document is basically documentary evidence. Right? Hearsay evidence, documentary evidence. I hope you have a clarity on it. Fine. So let us talk about this. How can the dying victim give the statement? Right? Remember, he can give it in any form. Fine. It can give an oral statement, right? Or if it is possible, the victim can write, that is even more valid, a written statement can be given. If suppose the person is not able to give oral statement or written statement, even by gestures or even by signs, right? The person can give this dying declaration. That is again very, very, very important, right? Very, very important. Right? I hope you remember when I was talking about the common witness, I told you that any person can be a common witness. Any person can be a common witness. Even a dumb witness can also give evidence in the court of law by means of signs and gestures. Right? The same thing applies here as well. See, the dying person at the time of dying, he can give a statement either in the oral form or it can give it in written form, right? He can write himself or he can give gestures or signs, right? If you, for example, you can remember, I hope you remember the Nirbhaya gang rape case which happened in December 2012, right? In that case, the victim gave 3 dying declarations. Right? On 16th, I think the incident occurred on 16th of December 2012. On 16th of December 2012 itself, the doctor who treated, the doctor has recorded 1 dying declaration. After some time, again, 21st of December, another dying declaration was recorded by the magistrate. Okay, and 25th of December, again, 1 more dying declaration was recorded. But on 25th of December, the victim was in a very critical state. The victim was not able to talk. Right? That dying declaration was recorded by means of gestures and sign, and that was admitted as an evidence in that particular case. Right? That was admitted as a valid evidence in that particular case. So that's why, do remember, it can be given in any form. So this is dying declaration again. It is given by the section 32(1) Indian Evidence Act. So we are talking about evidence, right? So this is about Indian Evidence Act. Now moving further, let's talk about the other things about dying declaration. Who can record this dying declaration? As per law, the law has not mentioned that this person has to record dying declaration. Anyone can record dying declaration. Do remember, anyone can record. There is no mention in the law that only this person is valid enough to record the dying declaration. It's not like that. Ideally, it is done by the magistrate. Right? Executive magistrate can record, ideally. Suppose if the situation is so critical that you are not able to bring the magistrate, there is no time left for you to wait for the magistrate. In that situation, even a doctor can record dying declaration. Right? If it's not possible for doctor to record, police can record. Even if the police is not available, any common public can record. But do remember, if it is done by any of these people, it has to be done in the presence of 2 witnesses as well, so that you are ensuring that there is no tampering of this kind of evidence, right? There is no fabrication of this kind of evidence. So you need to have 2 witnesses at the time of recording. The 2 witnesses also have to sign at the end of this dying declaration. Fine. But you can see that though it can be recorded by anybody, the value will keep on. Ideally, it is done by the magistrate. But if it is done by any other person, the value keeps on coming down. Right? The value keeps on, reliability keeps on, credibility keeps on coming down. right? Fine. Now going forward, you can see when it is valid. When can you say this particular dying declaration is valid? Number one, it has to be recorded by a victim who's in sound mind. That is highly important, because it is highly possible that the person may not be in sound mind. The person at the time of critical state, the person about to die, the person may be in altered sensorium, the person may be in semi-consciousness, wherein the dying declaration will not be considered valid. Right? Fine. See, when you are recording this dying declaration, remember the person has to be in clear mind. The composed mentis, then only you can start recording the dying declaration. Who's the best person to find out whether the victim is in sound mind or not? Yes, of course, it is the doctor, right? Fine. So the primary role of a physician here, the primary role of a doctor is basically to record, to certify whether the dying person is in composed mentis or not, right? This is highly important. This is the primary duty of a doctor. This is the prime duty of a doctor. If the doctor doesn't certify the person is in composed mentis, you cannot even start the procedure. Fine. And the doctor has to certify that the person isn't fit enough to give the dying declaration. That is a primary duty of a doctor. And do also remember, see, this composed mentis is to be examined throughout the dying declaration. While you start, throughout the procedure, at the end of the declaration as well. Suppose the person wasn't composed mentis during the start of the procedure, but while you keep on recording, the person slips off. Right? The person slips off his mind and the person goes into semi-conscious state, then you have to stop the dying declaration at that point itself. Right? You need to stop the dying declaration at that point itself. You have to conclude that procedure. Fine. So that is the reason why that you need to keep on examining. You have to keep on ensuring that the victim was in composed mentis or not throughout the procedure. That is again very important. This is done by the doctor. The primary duty of the doctor is not for recording the dying declaration. During the dying declaration, the primary duty of a doctor is to certify composed mentis, not for recording, because recording can be done by any person. Recording can be done by any person. Fine. Right? Fine. Now let's move on. The next point, no force or influence. Right? The dying declaration has to be given without any force or without any influence. It has to be complete. This is again very important. Complete. Fine. Suppose if the dying person is saying that when I was going on the road in front of the Raju house, Ramu came with a knife and stabbed me. It's a complete statement. This is fine. But at the time of giving this kind of declaration, he is telling that I was going in the road in front of the Ramu house. Rai was stabbed by. He stopped. He died there itself. Right? I was stabbed by. He stopped there. He died there itself. You cannot fill in the blank by any other name which you want. Right? So that cannot be done. Fine. So the statement has to be complete. If the statement is incomplete, then it is not so valid. Fine. Suppose whether if the person is saying like this, I was going on the road in front of the Ramu house, Raju stabbed me, then he ran, he just died there itself. Right? Even though this statement is incomplete, he conveyed the message. Right? So this particular kind of statement can be taken as valid, and do remember it is not for us to know whether it is valid or not. So whether the completeness or incompleteness of this declaration has to be ascertained by the presiding officer of the court. So it will be judged by the presiding officer of the court, right? Whether it is complete or incomplete, the completeness of the dying declaration will be ascertained by the presiding officer of the court. So do remember that is about completeness. Then the cause of death should be the question. So at the time of dying declaration, he is giving a statement. The statement should be related to the unlawful act, and it is about this cause of death. Right? He should not talk about something else. Right? Then it is not a dying declaration at all. Right? And this person should die. Right? If the person dies, then it will be considered as valid. Fine. Suppose if the person survives, then it is not valid. Fine. Now look at the procedure. The first important thing is, normally when we take evidence in the court of law, the first thing I told you that it is compulsory that we need to take oath. Right? Remember, in this case, the person who's dying, right? It is assumed that the person who's dying at the time of death, he will not lie. Right? He will not meet the God with the lie on his mouth. So we assume like that. So no oath is taken for dying declaration, and no alteration of the words. You should not alter the word. Suppose if the victim is saying, right, I was stabbed by Ramesh, right? You are changing, I was stabbed by Suresh. You are changing that, you are altering the word. You are paraphrasing the word. All these things should not be done, and you should not prompt. You should not have any leading question. This person only stabbed you. This person was stabbed you. Yes or no? You are not supposed to ask any leading questions like that. No alteration of words, no prompting of words, no leading questions should be done. But it can be in the form of question and answer. If suppose you don't understand, if you're in doubt what the victim was trying to convey, or if the statement given by the victim is not so clear, you can make it clear by asking question, but the question and the answer should be recorded in the dying declaration. Right? Both the question that you asked and the answer that the victim has given, both have to be recorded in the dying declaration. Right? I told you no leading questions. Right? I also told you question and answer format can be done. Both are different. We'll discuss what is leading question later. Fine. And do remember, it has to be verbatim, that I told you that you should not change anything. It has to be word by word. You should write whatever it is told by the patient. And of course, it should be preferably in the same language. Right? It's so obvious that it has to be in the same language. It is preferable that to be having the same language. After completing the dying declaration, you need to sign it. Right? You need to get the signature of the victim, or you need to get the left thumb impression or thumb impression from the victim, and you sign it. The witnesses have to sign, and then it has to be forwarded to the magistrate as early as possible, as soon as possible, ASAP. Fine. Right? So this is about the procedure about dying declaration. Now coming again to the validity. I told you just now, if the person dies, if the patient dies, then it is valid. Suppose if the patient survives, that is possible, right? That is very much possible. Because of your miraculous treatment, if the patient survives, in that situation, what happens is this dying declaration will be invalid. But this document, see, anyway, this person is alive. I told you earlier why this dying declaration is taken as evidence in the court of law, because this person is dead. He will not be able to come to the court. That's why it is considered valid if he dies. Suppose if this person survives, anyway this person is alive. He has to come to the court to give oral evidence. That is the reason why this document becomes invalid. Right? This person, victim is alive, he'll come to the court, he'll give oral evidence. But this document itself will be taken as corroborative evidence. Suppose if he comes to the court and he gives evidence contrary to what he has mentioned in the dying declaration, right? In that kind of situation, this document will be used as supportive evidence. Right? Supportive evidence. Corroborative means supportive. So this is used as a corroborative evidence in the court of law. Fine. So do remember, this is about the validity. And there is one more important procedure, that is called dying deposition. Dying deposition. It is commonly called as bedside court. That means you are conducting court in the side of the bedside itself. Fine. This is another procedure which is similar to dying declaration. This is another procedure similar to dying declaration. Let's see how this procedure is being done. Remember, here only the magistrate can record. I told you in dying declaration anybody can record, but here only magistrate can record, nobody else can record. And this deposition, see, it is the word depose. You're giving evidence just like in the court. How do you give evidence in the court of law? You need to take oath. Likewise here, oath is compulsory. Oath is taken. And this deposition is done in the presence of either accused. It is done in the presence of accused or defense lawyer. Accused lawyer will be there. Right? Either it is done in the presence of accused or defense lawyer. If the defense lawyer was there, right, he will conduct what is called as cross-examination. We'll discuss about the court procedures after this. So just do remember, cross-examination will be done by the defense lawyer and leading questions are permitted. Leading questions are permitted. Do remember, in dying declaration, leading questions are not permitted, but here leading questions are permitted. Fine. So here you can see that whatever you do in the court of law, it is just like done on the bedside itself. That is why it is called bedside court. Dying deposition. And if you see the validity of this, whether the patient survives or if the patient dies, it is valid very much. Right? Even if the patient survives or if the patient dies, it is valid because it is recorded in the presence of magistrate and cross-examination is also done. Fine. And dying declaration and dying deposition, two procedures we have discussed right now. Which is superior? Dying deposition is superior than dying declaration because it is valid whether irrespective of the person dying or the person surviving. Okay, and this is not practiced in India. Do remember, it is not practiced in India. In India, we have what is called as dying declaration. I told you 32(1) Indian Evidence Act. We don't have a section for dying deposition because that is not followed in India itself, right? So it is not in India, whereas dying declaration, that is practiced in India. If you compare, dying deposition is superior to dying declaration. Right, so let's go forward. We'll talk about recording of evidence in the court of law. This is again very, very important area which is fruitful, very, very productive area for your examination purpose. Right? So this is important for your understanding, this is important for your conceptual knowledge, and it is also important for your MCQ solving. Recording of evidence in the court of law. See, this recording of evidence, if you want to record evidence in the court of law, all this starts with the presiding officer of the court issuing summons to you. The court issues summons, you need to go to the court of law. When you go to the court of law, do remember here what happens is see, when you go to the court of law, you will have judge. Of course, judge will be there. There can be public prosecutor. See, we discussed earlier in case of civil case, it is between two parties, A versus B. So the lawyers will be party A lawyer versus party B lawyer, or plaintiff lawyer, defendant lawyer. Right? But if it is criminal case, I also told you that in criminal case, what happens is, it is the government will file the case on behalf of the victim because it is the duty of the government to safeguard the rights of the citizens. Right? If there is any crime occurring to the citizen, it is a duty of the government to file the case. Right? So what happens here is, here it is not it is not plaintiff versus defendant. Here it is the prosecution. Prosecution is appointed, it is the government side, right? On behalf of the victim, the prosecution will file the case that will be defended by the defendant. Defendant is the accused, right? So it is basically the prosecution side versus defense side in case of criminal case. Do remember criminal case. Fine. And the lawyer appointed by the prosecution will be called as public prosecutor. The lawyer appointed by the accused will be called as defense lawyer, or you can say defense counsel. So I've given you a brief summary of the difference between civil and criminal. Civil, I told you, it is between two parties, and criminal, it is between the prosecution versus defendant. In criminal case, you can see that it is a public prosecutor versus defense lawyer. Our discussion will be focused only towards criminal case because assuming that we are the medical witness, we have done, we have issued the medical legal certificate, right? Medical legal report. Let us assume that we are the autopsy surgeon. We have done post-mortem related to a particular case of murder. Since you have issued autopsy certificate, right, the post-mortem certificate related to the cause of death, you have given an opinion, you have given your opinion related to the cause of death, and you are called to the court as an expert witness. Fine. Usually the expert witness in this case will be called by the public prosecutor, right? You will be appearing on behalf of the prosecution. Fine. So now let us discuss. You go to the court of law, you have received the summons, you go to the court of law. Three people are there. Number one, judge. Number two, public prosecutor. Number three, it is defense lawyer. Now, after going to the court, you see that, let us see few important points related to the recording of evidence in the court of law. Do remember, always the recording of evidence should be done in the presence of accused. In the presence of accused. Recording of evidence will always be done in the presence of accused or his lawyer. I told you defense lawyer, right? Defense lawyer or his lawyer. You also know this kind of recording. Sometimes, see, normally you go to the court of law, you depose evidence. But sometimes when it is not possible, it can also be done. It can also be done with audio-visual aids. Audio-visual aids. right? You can also, recording of evidence is also being done through video conferencing. That's called audio visual aids. Now, one of the most important thing that you have to know here is, see, what is a sequence that you follow in the recording of evidence. Recording of evidence, right? What is the sequence? Number one, the first procedure is oath. The first procedure is oath. Only when you take oath, continue, the recording will start, right? Recording of evidence will start. After taking oath, it is followed by what is called as chief examination, which is also called as direct examination. After chief examination, right, cross examination will be done. Do remember, cross examination will be done. That is done, right? That is done after chief examination. After cross examination, we have what is called as re-examination, which is also called as redirect examination. Fine. I told you oath, then you have direct examination, cross examination, redirect examination. This is a sequence that you follow in the court of law. We call it as order of trial. This is the order of trial in the court of law. But this is given by the section 138 Indian Evidence Act. Right? Do remember, this is about recording of evidence in the court, right? So this is given by 138 Indian Evidence Act. Fine. So let us discuss one by one. Let's start with oath, right? Which is very, very important, highly important. Oath. How do you take oath? What do you say in oath, right? I do swear in the name of God. In the name of God, whatever I shall state shall be the truth, the whole truth, nothing but the truth. You're talking truth, you're talking the complete truth, that is whole truth, and nothing but the truth. Nothing but the truth means you are not inserting your own statement into that, right? You're talking, you're mixing something, truth and false both together, you're giving evidence. It's not like that. You're talking truth, the whole truth, you're talking nothing but the truth. That means you're not fabricating, right? Truth, the whole truth, nothing but truth. Fine. Suppose if you are not willing to give evidence, you are not willing to take oath in the name of the God, right? I don't believe in God. In that case, if you say so, if you say that I don't believe in God, you are an atheist. If you are an atheist, do remember, still you need to take oath, but you do have to take solemn affirmation, right? I do solemnly affirm that whatever I shall state shall be the truth, the whole truth, nothing but the truth, right? Oath is compulsory. Do remember, oath is compulsory. You need to take oath. Oath is compulsory. If any person, if any witness refuse, if any person, any witness refuse to take oath, that is punishable under 178 IPC. This is punishment, so it is not IEA. This is 178 IPC, right? There is only one exemption for taking oath. What is that? A child less than 12 years exempted from taking oath in the court of law. Exempt from taking oath. But you do have to be very careful, friends. You have to be very careful here. I did not say a child less than 12 years cannot give evidence. I didn't say so. We discussed earlier itself, for a person, for a witness, for a person to be a witness, there is no age limit. Any age person can be a witness in the court of law. But if the child is less than 12 years, the child need not take oath, but can give evidence. Need not take oath, can give evidence. Fine. Suppose if the person is saying that I do swear in the name of God, right? Whatever I shall say shall be true, the whole truth, nothing but truth. After taking oath like that, if he gives false evidence, right? Whether he takes oath in the name of God, or he is giving solemn affirmation, he may tell false evidence, right? It is not a guarantee that he will always tell the correct evidence. He may give false evidence. In that case, false evidence after oath, false evidence under oath, it is called as perjury. Do remember, it is called as perjury. Fine. And remember, if any person is giving false evidence, any person is giving false evidence after taking oath, it is defined under 191 IPC, right? And if any person fabrication of evidence, I told nothing but the truth, right? If he's inserting his fabricating the evidence, that is defined by 192. But remember, both false evidence and fabrication punishable under 193 IPC, right? Either false evidence or fabrication of evidence, that is punishable under 193 IPC. This is very important. 191 is definition, 192 is also definition, 193 is punishment for both fabrication and false evidence. Right? Do remember the terminology perjury. Sometimes they may ask you the perjury term itself. So you need to know definition is given by 191, whereas punishment is given by 193. So oath is done. Fine. Now let's go forward. After oath, they'll start asking questions. They will start examining the witness. Right? The first stage in this examination, that is called chief examination. The first stage in this examination, it is called as chief examination, which is followed by cross-examination, which is again followed by re-examination, which is also called as redirect examination. Why this is called redirect examination? Because chief examination is also called as direct examination, cross-examination and re-examination. Fine. Now you see, who can conduct this chief examination? Chief examination is conducted by same side lawyer. That is an easy way that you can remember, right? Same side lawyer, right? Cross examination, you're going to the opposite, crossing. This is done by the opposite side lawyer, right? And redirect examination is also again done by the same side lawyer. Right? So you have same side lawyer, opposite side lawyer and same side lawyer. This is very, very easy to remember. Right? That's the easiest way you can remember. Chief examination done by same side lawyer, cross examination is done by opposite side lawyer, and re-examination is also done by the same side lawyer. Now, see the direct examination. What is the purpose of direct examination? So let us look at the objectives of these different examinations. Right? The first examination, chief examination. See, the chief examination, I told you the same side lawyer, right? Whichever lawyer has called you as a witness, that particular lawyer will conduct chief examination. During chief examination, the lawyer will try to place all the facts about that particular case in front of the presiding officer of the court, that is judge. And he will, suppose if you happen to be a medical witness, he will present your opinion about your interpretation of facts and all these things will be produced in the court, right? In front of the judge. This is chief examination. After which cross-examination will be done, wherein I told you cross-examination is done by the opposite side lawyer. Wherein this opposite side lawyer will try to find out any new fact which is favorable to him. Right? Favorable to him, to his party. Fine? Whatever evidence that you have given, from that evidence itself, he will try to find any new fact favorable to his party. And he will also try to test your accuracy. Doctor, you have told something like this, but the finding was not looking like that. He will try to test the accuracy of the statements. Not only that, he will try to discredit the witness so that the credibility of the witness comes down. He will try to reduce the reliability of the witness itself by discrediting the witness. Doctor, you have not even done MBBS. Right? How can you be a forensic medicine expert? Doctor, you are not a qualified MD forensic medicine expert. You don't have sufficient experience in the field of forensic medicine. How can you do autopsy and how can your autopsy opinion will be reliable? He can ask anything basically to discredit the witness. Right? So that is basically done during cross-examination. Right? He will test the accuracy. He will try to test the reliability. He will also try to discredit the witness so that he will elicit few facts which is favorable to his party. If there is any doubt that is appearing during cross-examination, right, in re-examination, it will be clarified. The re-examination again will be done by the same side lawyer. He will try to clarify that as any doubt that has appeared during cross-examination. Right? He will try to give more explanation or he will try to clarify some doubts which is due to cross-examination. But do remember here, during re-examination, no new facts should be presented. if any new fact has been elicited during this re-examination, right, then again it will be followed by recross examination. Right, recross examination will be done only when there is any new fact which is taken during redirect examination. Otherwise, it is chief examination, cross examination, re-examination. I told you the three important examination, right? We know already chief examination is done by same side lawyer, cross examination done by opposite side lawyer, and re-examination is also done by same side lawyer. Now, there is something called leading questions, right? Leading question. What is a leading question? You are leading the witness to the answer. You are leading the witness. You are suggesting the answer to the witness. You are suggesting the answer to the witness. That is called as leading question. Basically, it just needs yes or no answer. Right? Doctor, what is the length of this incised wound? You say 7 centimeter, 8 centimeter, 5 centimeter, whatever it is. That's a normal question. Doctor, is the length of this incised wound is 7 centimeters? That is a leading question. He is suggesting you that is 7 centimeter. You just have to say yes or no. Doctor, falling from height, landing on the feet can cause fracture like this in the base of the skull. Yes or no? You just have to say yes or no. Right? Doctor, what is your name? That's a normal question. Is your name Dr. So-and-so? That's a leading question. He is suggesting the answer to the witness itself. He is leading the witness to the answer. That is called leading question, which basically needs yes or no answer. Do remember, this leading question can be asked only by the opposite side lawyer. Only by opposite side lawyer. It cannot be asked by the same side lawyer. Usually. Right? We'll discuss about the exceptions. It is usually asked only by the opposite lawyer. That means, right? That means only in cross-examination, leading questions will be permitted. Let us see leading question. Right? If it is leading question, in chief examination done by same side lawyer, leading questions not permitted. Right? Cross-examination is done by opposite side lawyer, so leading questions are permitted. In re-examination, again is done by the same side lawyer, leading questions are not permitted. Do remember, leading question is given by the section 141 Indian Evidence Act. Right? Indian Evidence Act. Leading question, the conditions where leading questions are not permitted, that is given by not permitted. Not permitted is given by 142 Indian Evidence Act. Permitted is given by 143 Indian Evidence Act. Right? Just for extra information. Right? Usually these kind of sections are not asked in your examination. You just know the section which is defining leading question, that is 141 Indian Evidence Act. That is fine. Right? So this is the trial that is happening. I told you that you can see there are three important people in the court of law. One is public prosecutor, right? Defense lawyer and the judge. Right? Who will ask questions? Right? Everybody will ask question. Right? Suppose, see, I told you public prosecutor is appearing on behalf of the government. It is appearing on behalf of the government, basically in the side of the victim. Defense lawyer is appearing on behalf of the accused. Right? If the public prosecutor has summoned you, if you are a government doctor who has conducted autopsy, right, on behalf of the government, the public prosecutor will be summoning you as a prosecution witness. Right? Suppose if the defense lawyer is asking somebody to come to the court of law for giving evidence, then the person will be called as defense witness. So you can either be a prosecution witness or you can also be a defense witness depending on the case. Right? Let us say I told you, you can be a prosecution witness, you can also be a defense witness. If the public prosecutor has summoned you, you are called as public prosecution witness. If your defense lawyer has summoned you, then you will be called as defense witness. Now, who will conduct chief examination in prosecution witness? Do remember, prosecution witness, who will conduct chief examination. Chief examination of prosecution witness will be conducted by the same side lawyer, public prosecutor. Cross-examination will be done by the opposite side lawyer, that is defense lawyer. Re-examination will also be done by the same side lawyer, that is your public prosecutor. In case you are a defense witness, you are appearing on behalf of the defense side. You are appearing on behalf of the accused. Right? In that case, the chief examination will be done by the defense lawyer. Cross-examination will be done by the opposite side, that is public prosecutor. And re-examination will also be done by the same side, that is defense lawyer. So this is one important point which have been multiple times asked in an examination. Who will conduct cross-examination in public prosecution, prosecution witness, and who will conduct cross-examination in case of defense witness? This is one question which was continuously being asked in the examination. It is very, very simple. You just have to know if it is cross, it is opposite side. As simple as that. Right? But you should basically know which side you belong to, right? Whether who's your same side and who's your opposite side, that you should know. Right? If you're prosecution witness, your same side is public prosecutor. If you're defense witness, your same side is defense lawyer. Right? So you should basically know that. Fine. So this is about the recording of evidence in the court of law. This is the sequence that is being followed. But here again, do remember, I told you, the public prosecutor will ask question, the defense lawyer will ask a question. What about the presiding officer of the court, the judge? When will he ask question? When will he ask question? Do remember that is given by power of the judge is given by 165 Indian Evidence Act. He can ask any question. He can ask to anybody. He can ask at any stage of the trial. Right? Anything to anybody at any stage of the trial, which is specifically mentioned in 165 Indian Evidence Act. Questions by the judge. Right? You can say judge questions. Questions by the judge can be asked at any stage of the trial. There is no specific criteria. There is no specific restriction. Right? Do remember, he is a presiding officer of the court. This is point number 1. Point number 2, if the presiding officer of the court, if the judge feels that he needs to have more clarity of a particular evidence, he can recall any witness. Right? He can recall any witness. He can re-examine any witness depending on the case if he feels it is needed for the case. Right? The judge has the power to recall or re-examine any witness in the court of the law. This is given by 311 CRPC. Basically, the section is not so important, but do remember the power of the judge. Power of the presiding officer of the court. Fine. So this is again very, very important. Let's talk about leading question. Leading question, I told you that it has got yes or no answer, but it's a double-edged sword. What happens here is, let me take you an example of a case which I did many years back. You see, one 28-year-old female was brought to the casualty by her husband, brought dead, right? The husband is telling that I was out of station for 2-3 days. I just came today morning only, but when I returned, I could see the door was locked from inside. I tried, nobody opened. I broke the door open. I went inside. My wife was found dead in the bed. Right? I didn't know what happened. Then this is a broad dead case, so you have to do medical legal autopsy. As an unnatural death, we need to do medical legal autopsy. But when I was doing this procedure, I could see multiple injuries all over the body. Multiple contusions were there all over her body. Multiple contusions. Multiple means multiple. 45 areas of contusion present throughout her body. And internal dissection, all the organs were completely pale. All the organs were completely pale because even one contusion, they say 30 to 40 ml of blood will be there. 45 areas of contusion, imagine the amount of blood loss. Right? So all the internal organs were completely pale. I gave the opinion the person died of effects of multiple blunt force injuries sustained. Right? Shock and hemorrhage. Multiple blunt force injuries sustained. Right? Assuming this case is brought to the case, during chief examination, the public prosecutor will try to put all the facts in front of the judge. During cross-examination, defense lawyer, he can ask leading question. First, he will say normal question. Doctor, where are you working now? Where did you do MD forensic? Have you completed MD forensic medicine? Where are you? Where did you do MD forensic medicine? I'll say Institute of Forensic Medicine, Madras Medical College. Right? How many years of experience that you've got, how many cases that you have done, all these things, what is your academic performance, all these things, he can ask anything, right, for the credibility, right? And then he will ask, doctor, is it possible when a person is walking on the floor and the floor was wet and the person fell down, there was a blunt weapon object over there, like a stone or something, on hitting at the skin, is it possible possible for the person to have contusions like this, bruises like this? Just tell me yes or no. You can say yes, right? So if the weapon happens to be having a blunt surface, if the object happens to be having a blunt surface, then it is possible the person to have a contusion or bruise, depending on the type of object, depending on the type of object. But here the person tries to misinterpret the fact. Right? The person tries to misinterpret, but as a medical expert, you know very well that these injuries are not due to the effect of stones. In this kind of situation, when a medical expert witness or when any expert witness feels that there could be a misinterpretation of the fact, here with the permission of the court, the expert witness can do what is called as volunteering of statement. Volunteering of statement can be done by a witness with the permission of the court. You can ask permission from the judge. Your Honor, I would like to have one clarification. I would like to state one clarification. Right? It is not possible for the victim. It is not possible for the victim to have fall on the ground 45 times on different angles, so that the victim will have 45 areas of condition throughout her body in all the surfaces of the body. Right? So this kind of injuries is possible only because of the multiple injuries sustained to the body by an impact, by a blow. Okay, so you can basically, whenever the witness feels that there could be misinterpretation of finding, volunteering of the statement can be done with the permission of the court. This is called volunteering of statement. With the permission of the court, it can be done expert witness. Right? Expert witness. Fine. So I've told you all these terminologies to understand. There is one more very important point that you have to understand is, see, basically I told you have chief examination, cross-examination, re-examination. If you know which side you belong to, you can easily find out same side lawyer, opposite lawyer, and you can find out who can conduct all these examination. There is one important thing, terminology, that is called hostile witness. Who's an hostile witness? There is no section in the IEA mentioning the definition of hostile witness. But still, let us understand what is basically hostile witness. Hostile witness is also called as adverse witness, also called as unfavorable witness. You are not favoring the side which has called you. You are not favoring the side which has called you. If the public you are appearing as prosecution witness, you are going to the court as prosecution witness, right? And you are not giving evidence favoring the prosecution side. That is called unfavorable witness. During the initial part of the inquiry, you told that, yes, sir, I have seen this murder. I saw person A stabbing person B. Right? You are included as an eyewitness in the case. You have been summoned by the prosecution, public prosecutor, as a prosecution witness to the court of law. You go to the court of law as a prosecution witness, as an eyewitness. Right? After going to the court of law, in front of the judge, you are telling that, no, sir, that day it was so dark. I could not clearly see who stabbed whom. Right? I could not find out who was standing with knife properly. It was so blurry. It was so dark. So I am not sure about who was stabbing whom. Right? You are not favoring the side which has called as unfair witness. Right? You see, the hostile witness is basically the person who conceals the truth. Right? The witness who conceals the truth, the witness who is not favoring the same side. That's why it is called unfavorable witness. Not only that, it is contradicting your own previous statement. Initially, you told that you saw the offense, A stabbing B. Now you are telling that I did not, I'm not sure who stabbed whom. That time it was so darker. Right? You are contradicting your own statement. Right? The witness is contradicting his previous statement. Either the witness concealed the truth, or the witness is not favoring the same side, or the witness is contradicting his own previous statement. All these things will be called as hostile witness. Hostile witness. Right? What is the medico-legal importance here? The medico-legal importance is normally the leading questions can be asked by the opposite side lawyer. But here in this says, if any witness is declared as hostile by the judge. Who will declare the witness as hostile? The judge will declare the witness as hostile. Right? If the public prosecutor is saying, sir, this witness has turned hostile, right? The judge will declare the witness as hostile. In that case, even the same side lawyer can ask leading question. Right? Normally, the same side lawyer should not ask leading question, right? But here, the same side lawyer can be asking leading question. That is the most important point that you need to remember. It is called hostile witness. Hostile witness. Right? 150 154 Indian Evidence Act. 154 Indian Evidence Act. Fine.